Welcome, everyone. Thank you all so much for joining us today for the Environmental Law Institute's third session of our summer school series on the basics of the Clean Air Act. We're coming at you live from Washington, D.C., but there's also a sizable audience online via Zoom as well. So we're so excited to see you here, no matter if you're joining us online or in person. This is our third session of summer school. If you missed the first two sessions, you can find the recordings on ELI's website or YouTube page. So as you can see on the screen behind me here, we will be coming back in 2 weeks, again in person for our climate change session, and then next week we'll be online for our energy session. All sessions of summer school will be recorded and uploaded to ELI's website for folks to watch later. So if you miss any portions, be sure to check back. And also our slides are located on the event webpage. So if you're watching online, we will drop those in the chat so that you can follow along. And we will be taking questions at the end of today's program. If you are in person, just hold on to your questions until the end, and we'll come along with microphones so that the online folks can hear you. If you're online, feel free to enter your questions into the Q&A box as soon as you think of them. There's no need to wait until the end. We will also have the chat open if you want to interact with one another throughout the program. However, ELI will not be monitoring the chat for questions, so be sure to put your questions in the Q&A box rather than the chat. I'll now hand things over to our wonderful moderator today. Karen Montgovin is the Policy Director at the National Association of Clean Air Agencies, which is a nonpartisan, nonprofit association of 155 state and local air pollution control agencies across the United States. It is dedicated to advancing the protection of clean air and public health and strengthening the capability and effectiveness of state and local air agencies. In her role, Karen coordinates the public policy communications and serves as the association's legal expert. She also directs the association's activities related to Title V and new source review permitting, air toxics, ambient air monitoring, air quality modeling, and emissions inventory issues. Before joining in 2013, Karen spent 9 years as an attorney in the Environmental Group at Sophie Austin. She holds a JD from Georgetown University Law Center, and I'll hand things over to her to get us started today. Thank you all so much for coming out.
Thank you so much, Madison. And again, welcome everyone to the 2025 edition of ELI Summer School. Today, we have three fantastic instructors who will be covering the basics of the Clean Air Act, which is indeed one of the most complex and consequential and successful U.S. statutes that are protecting human health and the environment from pollution. Before I introduce our instructors, I'm going to take a few minutes to lay out the background for today's session, beginning with a brief history of the Clean Air Act itself and how the statute has developed over the past decades. So federal air pollution control law began with the Clean Air Act of 1963, but the first truly comprehensive statute and the origin of the Clean Air Act as we know it today began in the Clean Air Act amendments of 1970. This is what created the basic structure of the modern act, and it was the first of several media-specific environmental statutes that were enacted in that time period. Also, the U.S. Environmental Protection Agency was created in 1970. It was definitely a very significant time period for environmental law in the United States. The centerpiece of the 1970 Clean Air Act was the system whereby EPA sets health-based national ambient air quality standards, or NAAQS, as we call them, for the major ubiquitous air pollutants that are known as criteria pollutants. And states developed implementation plans to achieve those standards. Now, since 1970, there have been two comprehensive sets of amendments to the Clean Air Act. The first were in the Clean Air Act amendments of 1977. And a key element of those amendments was the addition of a pre-construction permitting requirements, and we call that new source review permitting. And it requires facilities to obtain air permits before they're allowed to begin construction or to make a major modification of a facility. But by far the most extensive amendments to the Clean Air Act, the ones that greatly expanded it, were the Clean Air Act amendments of 1990. And that is the statute that we have today with very few adjustments. So that included the creation of the operating permits program for existing facilities, the acid rain program, a great expansion of the provisions related to air toxics, stratospheric ozone protection provisions, as well as tighter standards for mobile sources and expanded enforcement provisions. And the 1990 law in sum was an enormous piece of legislation, and it passed both the House and the Senate by large margins of 400 to 1 to 21 in the House and 89 to 11 in the Senate. I'll just say it's inconceivable that such an environmental statute would pass in today's much more divided political environment where, unfortunately, I think environmental issues have become more partisan. So it's quite a statute, would never pass today. I will add as well that the Clean Air Act is an enormously successful piece of legislation. And in fact, it's widely considered to be the most significant public health legislation ever passed in the United States. Since 1970, the combined levels of the 6 criteria pollutants have dropped by 78%, according to the most recent numbers available, which was really something. But that said, there are many, many challenges that remain, and we do have a lot of work left to do in cleaning our air. We still face persistent non-attainment problems in some areas of the country. Reducing greenhouse gas pollution that contributes to global climate change is a key challenge and one that is politically fraught, as we all know. Air toxics, these are the hazardous air pollutants, the ones that are poisonous and at small quantities. These are coming into increasing focus these days, especially as our understanding of the health science improves and our ability to measure these pollutants at the very low levels improves as well. And we have communities in this country that persistently are disproportionately burdened by air pollution and by the cumulative effects of multiple pollutants. And there's structural reasons, perhaps the Clean Air Act has some difficulty in addressing this kind of a persistent problem. Okay, so changing gears for a sec, because I work at NACA, which is the National Association of State and Local Air Pollution Control Agencies, I'd just like to say a few words about the very important role that state and local agencies play in implementing and enforcing the Clean Air Act. In fact, the Clean Air Act itself explicitly recognizes at the very first section that, quote, air pollution control at its source is the primary responsibility of states and local governments. So essentially, the Clean Air Act employs a model of what we call cooperative federalism. And this is perhaps best illustrated by its approach to addressing those 6 criteria pollutants that I mentioned earlier. It's set up in the Clean Air Act so that EPA takes the lead in setting the national ambient air quality standards at levels that are protective of human health and welfare. And then EPA is also required to review those standards every 5 years, which it does not generally do that on schedule, but that's a whole separate issue. Okay, so then the state and local agencies in turn are responsible for creating state implementation plans or SIPs that lay out how they're going to implement the NAAQS in their jurisdictions. They have a lot of tools in their toolboxes for doing this, and states approach these in different ways depending on their local priorities. And those SIPs have to be reviewed and approved by EPA. They're adopted into state law, but once they're approved by EPA, they also become federally enforceable. State and local agencies are responsible for a whole host of other activities as well under the Clean Air Act. They're responsible for running our air monitoring networks, which measure the concentrations of pollutants in the ambient air based on network design requirements that are established by EPA. So again, this is cooperative federalism at work. They also report that monitoring data to EPA and to the general public through a system called AirNow, which you might be familiar with. They collect emissions data from sources in their jurisdictions and submit that information to EPA as well. And they serve as the permitting authorities for most Clean Air Act permitting programs, which again, like SIPs, they have to receive EPA approval to do that. They also implement their own state and local environmental programs, which may be more stringent than those in the Clean Air Act. It's the state and local agencies that interact directly with stakeholders in their jurisdictions. They coordinate with federal and regional partners, and they essentially serve as the front line in terms of managing air quality in their jurisdiction. There are also programs in the Clean Air Act that are reserved for EPA to implement, and one of those is mobile sources, with an exception for California, which Alana will go into today. Okay, so our speakers are going to talk many of the major programs contained within the Clean Air Act, but as I noted before, the Act is large and diverse, and there isn't time to cover every single part. So I'm going to now quickly review the major sections of the Clean Air Act so that you get a general idea of what all's in there and where it falls within the statutory scheme. Okay, so there's 6 main titles of the Clean Air Act, and they are as follows. Title I focuses on establishing and implementing air quality standards, including the NAAQS and the requirement for states to develop SIPs, state implementation plans to meet those standards, as well as technology-based standards for hazardous air pollutants, also known as air toxics, the new source performance standards, which are technology-based standards for new stationary sources of air pollution, as well as standards for existing sources called emission guidelines. Title I also includes the Act's new source review pre-construction permitting program and the regional HAZE program. So today, Matt and Sean are going to cover most of these programs in their talks. Title II covers emissions from mobile sources like vehicles and aircraft. Alana is going to talk about the mobile source program today as well, including the renewable fuel standards program. Title III of the Clean Air Act includes its citizen suit and judicial review provisions. Alana is going to talk about some of that in her presentation as well. Title IV originally addressed noise pollution, and the 1990 amendments added the acid rain program to the Clean Air Act. This is a market-based cap and trade program for sulfur dioxide and nitrogen dioxide. We call that SOx and NOx. We won't have time to cover that today in any great detail, but I did want to mention it. Title V is the operating permits program. Matt's going to cover that. And finally, Title VI is the stratospheric ozone program, which was added as part of the 1990 amendments in order to implement the Montreal Protocol on protection of the ozone layer. And it focuses on phasing out the production and use of ozone depleting substances like CFCs. We won't really be able to cover that today at all, but it's worth going back and taking a look. All right, then. So without further ado, I'm going to introduce our three wonderful speakers now. All right, to my left, Matt Oakes has litigated Clean Air Act cases within the United States, or with the US Department of Justice, for over 20 years, where he's currently a manager of the Law and Policy section of the Environment and Natural Resources Division. Since 2011, he's taught a Clean Air Act class at the University of Maryland Carey School of Law. He also teaches classes on environmental law and oral advocacy at Georgetown University. And he's on the managing board of Anacostia Riverkeeper. Matt holds a JD from the University of Virginia Law School. Sean Goho is the legal director at the Clean Air Task Force. That's a nonprofit organization dedicated to advancing the technology and policy changes needed to achieve a zero emissions, high energy planet at an affordable cost. At the Clean Air Task Force, Sean oversees a team that engages in legal and regulatory advocacy in support of clean air, public health, and carbon-free energy technologies, in addition to providing strategic legal advice to Clean Air Task Force programs. Before joining CATF, Sean worked at the Emmett Environmental Law and Policy Clinic at Harvard Law School, Earth Justice, and Melvin and Myers. He holds a JD from Harvard Law School, as well as a Bachelor and Master's of Science degrees in biology from McGill University. And finally, Ilana Salzbart leads King & Spalding's Global Environmental Health and Safety Team, which was named Environmental Law Firm of the Year by Chambers and Partners in 2024. Ilana represents clients in investigations and enforcement actions initiated by EPA, the Department of Justice, and state environmental agencies, such as the California Air Resources Board, including related to requirements of Title II of the Clean Air Act. Before entering private practice in 2011, Ilana spent a decade as an attorney at EPA's headquarters in Washington, D.C., during which time she was involved in the enforcement of several environmental laws, including the Clean Air Act, the Resource Conservation and Recovery Act, and the Toxic Substances Control Act, among others. Okay, so Matt's going to start us off today by talking about the National Ambient Air Quality Standards and state implementation plans. Then he'll move into air permits, including NSR pre-construction permitting and Title V operating permitting programs. After that, he's going to switch gears and he's going to talk about one of the most significant Clean Air Act legal issues of the past 2 decades, which was the Supreme Court's Massachusetts versus EPA decision. And that case examined whether greenhouse gases can be regulated as air pollutants under the Clean Air Act. Then we're going to turn it over to Sean, who will continue the discussion of climate change regulation under the Clean Air Act and how that's played out in the years since Mass versus EPA. And Sean's also going to talk about how air toxics are regulated under the Clean Air Act. And then finally, Ilana is going to address the regulation of mobile sources under Title II, including the regulation of vehicles, engines, and fuels. She'll also discuss the enforcement provision in the Clean Air Act. Please hold on to your questions. We're going to take all of those at the end in one giant Q&A session for everyone. If you're participating virtually with us today, feel free to type those questions into the Q&A box on the Zoom, and we'll get to those when that session is ready. So with that, I'm going to turn it over now to Matt to get us started.
Great, I appreciate it. So I'll start by saying I've got some slides, but really what I'm going to try to do is talk you through some of the basic aspects of some of the programs of the Clean Air Act. It's got a lot of moving parts. I teach a full semester on the Clean Air Act, and we can't even cover everything in a full semester. So in an hour and a half, we're just trying to give you an outline here. But if you think about it, if your goal is to regulate the air, improve air quality, reduce air pollution, whatever it is, there's a bunch of different ways you can do it. And the Clean Air Act uses a lot of those tools, and it uses them in different ways, and maybe not consistently all the time. But one of the ways you can do it is you can directly regulate the air, right? You can set a level of a particular substance pollutant that you want in the air and say, if you exceed that, you're subject to enforcement. And so that's kind of, I think of it as the core of the Clean Air Act. Other tools might be, come up with a particular technology. There's a scrubber, and if you emit things from a stationary source like a power plant or a plywood factory or whatever it is, you need to install the scrubber, or you need a catalytic converter in your car, or a mobile source under the verbiage of the Clean Air Act. You can set technology standards, you can set emission standards. And so you can just say, I'm going to measure what's coming out of your smokestack. And if you exceed that, you're subject to enforcement. You can do a cap and trade. You can do a tax. These are all potential tools. The Clean Air Act, like I said, uses a lot of them. But the first thing I wanted to talk about is the National Ambient Air Quality Standards. And Karen mentioned these, but these I think of as the core. These are the regulation that the federal government sets, where it comes up with what are called criteria pollutants. These are pollutants that are widely dispersed across the country that cause harm to human health, cause harm to the environment. There's a way to designate new criteria pollutants. Right now, there's 6 of them. They're listed up on the screen, and we're not going to get too in the weeds of these, but NOx and SOx we already mentioned, particulate matter, either the small particles, PM 2.5, or the bigger particles, PM 10, ozone, lead. These are all things that are emitted broadly. And they're recognized to have human health impacts, and the federal government sets a level, a national ambient air quality standard that's periodically reviewed and adjusted based on the science. And once that level is set, then the states have to figure out how to meet the level. And so when I say it's the core, so many of these programs have an impact on these ambient air quality standards, even if you're regulating something else. Like, Karen mentioned I think Section 111, hazardous air pollutant, where they were regulating mercury. Well, mercury, the way you regulate it is you try to get the mercury to bind to a particle, and then you filter for the particle, right? And so there's a lot of the cap and trade program she mentioned, that impacted acid rain. Well, if you're controlling the constituents that form acid rain, you are effectively controlling some of these criteria pollutants. So it's not just a one-stop deal, is what I'm trying to say. But the NACs are the core of it. You set the NACs, and when you set the primary standards, EPA is looking, and the Environmental Protection Agency is the agency that's been tasked with administering the Clean Air Act. But when you set what are called primary standards, you're looking at human health. And you're saying, all right, what amount of ozone, what amount of lead can be in the air, and it still be healthy for humans to live, right? And so when you're considering human health standards, these primary standards, you don't consider cost. But EPA can also set what's called a secondary standard on the same substance, the same criteria pollutants, and you might ratchet it down a little bit, but there you consider costs, and your goal there isn't just human health, it's also the environment. So maybe things that go beyond purely a direct impact on human health. And so that's the driver of that is Title I. That's the driver of the Act, these national ambient air quality standards. And Also, as Karen mentioned, when you're trying to figure out, okay, you set a standard. That's great. You've got stuff floating in the air, and you go out and you either have too much of these criteria pollutants in the air, or you meet the standard. Well, if you have too many of the criteria pollutants in the air, what do? Well, that's where the states come in, and that's why the Clean Air Act is considered one of the paradigms of cooperative federalism. So the federal piece of it is setting this national standard that the states have to meet, but the states get to figure out how to meet it. So we're not telling anybody what they can or can't admit in setting the national ambient air quality standards. We're telling the state you have to achieve them. You have to come up with a way to do that. And the way you do that is through the development of what's called a state implementation plan, a SIP. And you'll notice if you spend any time with the Clean Air Act, there are a lot of acronyms, and I am trying to avoid using them here, but you'll run into them. So we already have NACS, National Ambient Air Quality Standards, that are implemented by the states in a cooperative federalism program through a state implementation plan. Well, what does that state implementation plan have to look like? Well, what it is a law. You know, the states pass a law that explains to the Environmental Protection Agency, this is what we're going to do under the laws of our states to achieve these national standards. And EPA looks at that law, and there's usually a lot of facts and science accompanying it, modeling, where the state explains, you know, if we ratchet down emissions from these factories, we're you know, right now we've got a problem with particulate emissions, and we're going to cut it down by this % through these mechanisms. And so there's this process that the state goes through, a science and technical and legal process, to implement its own series of state plans that will achieve these national ambient air quality standards. And it's complicated, and it's constantly changing. And when it changes, those changes also go to EPA, who reviews them and says, well, you know, we think it's going to work and we'll approve your state implementation plan, or we don't think it's going to work and we're going to reject. And at every step, it leads to litigation, which is why everybody at the table here is a lawyer. So that's the core. That's the essence of Title I, certainly, is these national standards of these criteria pollutants that are kind of everywhere that we're trying to reduce through state implementation plans. And the rubber meets the road in the states, setting up the laws, and then the states are proposing permits through a number of different permitting programs. And before the 1990 amendments, it was a little bit hard to figure out what particular requirements applied to a particular source. It was a problem. It was a problem for the sources because they were supposed to be keeping track of what they were doing. It was a problem for the states because they were trying to demonstrate that their programs were sufficient to meet the national requirements. It was a problem for anyone who wanted to enforce the act because, you know, step one, you had to figure out what standards applied, and that was hard. And so before I get into the weeds of the permitting, and I'm not, like I said, I'm not going to get too much into the weeds of anything. Part of figuring out what standards apply and which permitting programs apply is figuring out whether you're in attainment or non-attainment for the National Ambient Air Quality Standards, for the NACS, for these 6 criteria pollutants that EPA is regulating. And I apologize for repeating everything 3 or 4 times, but it's all interrelated and it bears reminder. All right, so you're a state, you got your SIP. The Clean Air Act also sets up nationwide monitoring programs. The states are also required to set up their own monitoring programs consistent with that. There's provisions that I could cite to you that you'd immediately forget that require EPA to do that. And so there's a way to figure out what emissions are in the air. And let's say you go to your emissions and you meet the emissions requirements for, we'll say, sulfur dioxide and nitrogen dioxide, but you don't meet them for ozone and lead. That means that one area of your state, and this area is called an air quality control region. Every state has at least one air quality control region. Many states have multiple air quality control regions. In other words, the state's divided into these little sampling areas, and you're trying to see, is this area in attainment or in non-attainment? And it's based on sampling that's required under the Act and required under the SIP. Sorry for talking fast. I'm trying to cover a lot. Okay, so if you're in attainment, that tells you what standards you need to meet. And similarly, if you're in non-attainment, it tells you what standards you have to meet. Now, what I've just described is a single area that's simultaneously in attainment for some of the national ambient air quality standards and in non-attainment for others. And that's pretty typical, right? Is like almost every area in the country is in non-attainment for something. Very few exceptions. I think there's one part of Minnesota that might be in attainment for everything, but they are technically in non-attainment, but actually in attainment. But that's more in the weeds than we need to get. So every area is probably simultaneously in attainment and non-attainment, and that means every area is applying to their stationary sources that are permitted. They're being permitted under both the non-attainment program and the attainment program. The attainment program seeks to prevent significant deterioration of the air quality. In other words, the Clean Air Act tries to make the air better, even if you meet all the NACs. And it tries to make the air better by setting goals for incremental improvements, called increments. It also tries to set standards through the best available control technology. So you still need to apply certain control technologies if you're in an area that's in attainment. But those control technologies are not as stringent as they would be if you were in non-attainment. So you're trying to make the air better, even if you attain. And the reason you want to do that is you don't want to set up a competitive environment where you're incentivizing industry to move to areas with good air because it's cheaper to operate your business there, which would then degrade the air quality of those areas. And so it was a strategic choice that was made by Congress that these attainment areas need to get better. Now, in a non-attainment, those areas need to get better faster. And so they set more stringent standards. The standards are called reasonably available control technology or lowest achievable emissions rate. The reason there's two standards is the RACT, reasonably available control technology, is used for existing sources that are already there, already emitting. But if you want to build a new source in an area that's not in attainment, then you need to meet even more stringent standards. Lowest achievable emissions rate. And that's the standard that's one of the most stringent standards under the Clean Air Act. I'm not sure where it would compare to the HAP standards, the hazardous air pollutant standards, but they're both really stringent. And it really probably depends on the setting. Okay. One other aspect that's worth knowing about applying standards in a non-attainment area where you don't meet the National Ambient Air Quality Standards, the NACs, is if you're in non-attainment and you're building a new source, you need to offset your emissions. In other words, you need to figure out a way as a state where you can build that new source, but take even more emissions offline that are going to be created by your new source. And so this is all done by projections and by incentivizing the closure of dirtier emitters. And so it can get complicated. This program has a lot of moving parts. So the essence of it, EPA, federal government, sets national ambient air quality standards. States figure out how to implement them. What happens if a state is unable or unwilling to implement the national ambient air quality standards? Then the federal government steps in and it creates another acronym, which it's really good at. Congress is good at creating acronyms too. This acronym is FIP. So unlike SIP, State Implementation Plan, there is a FIP, a Federal Implementation Plan. And so where a state is unable or unwilling to meet the national ambient air quality standards, the state says, well, this is how I'm going to do it. Now, states hate that, right? Because this, in essence, is control of your economy. This is figuring out what businesses run, what they emit, how expensive it is to run those businesses. And states want the level of nuanced control that you get by figuring out the emissions requirements for these stationary sources. And if the federal government is implementing a federal implementation plan, it's making the decisions about who can emit what within the state. And that's a lot of power, and states don't love it. And so states have a real incentive to create a state implementation plan that satisfies the requirements of the Clean Air Act, because if they don't, then what's behind that is the federal government stepping in and telling them what to do. Okay, so Now we know how we get our standards. So national standards, they're implemented by the state and state standards. How do they get to the emitting source? And we're not talking about mobile sources here. That's not part of the structure in the same way. That's dealt with in Title II. We're talking about stationary sources, and the requirements are attached to stationary sources through a permitting program. And so all of these acronyms, the BACT, RACT, LAIR, best available control technology, reasonable available control technology, lowest achievable emissions rate. You have to figure out what that means for a particular source. And so, there's databases. There's a BACT LAIR database. If you Google it, you can find it, and you can see what different states have applied under as each of these types of technology in their states, and other states can use it as a cross-reference. But what they're trying to do is figure out what standards to incorporate into your permit. So if you're a stationary source now, you're operating under a Title V permit. That Title V permit program was created in 1990, but the 1990 Title V program didn't add anything new to the standards. It just created a single permit that everyone can turn to figure out what each source is emitting. And so you're a source, you're emitting, you're monitoring your own emissions. If you're a citizen and you live near a power plant, you think that power plant is emitting too much, is emitting more than its permit would allow, and they've got self-monitoring data, you can look at that, and then you can compare it to the permit that sets the requirements that they're supposed to emit. And you can say, you're emitting X and your permit says Y, I think you're in violation. You can go to the state. State, I think you need to enforce. If the state chooses not to enforce, you can enforce. It's an incredibly powerful tool. It's a citizen supervision. It was created by environmental law in the 1970s. It was modeled after key TAM provisions. So it gives people an incredible amount of authority. So permits are source specific. They come through different permitting programs. If you're a new major stationary source and you are anticipated to emit at a certain amount, you're under one permitting program. If you're an area source and you emit less, you're under another. Everything's combined in the Title V program, but that's the essence of it. And I've only got a few minutes, so what I'm going to do now is I'm going to turn to Mass v. EPA and set that up. And I know Sean's going to talk more about the programs that are introduced in Mass v. EPA. But I wanted to touch on Mass v. EPA because it touches on another way to regulate emissions. Mass v. EPA is about emissions from mobile sources. And it's kind of got an interesting origin, and it's the most cited case in environmental law since Chevron, really, which doesn't exist anymore. But it's important. It stands for the proposition that if EPA makes a determination that emissions from cars endanger human health and the environment, it has authority under Title II of the Clean Air Act to regulate greenhouse gases. And it came along, strangely enough, because there was a relatively conservative congressman, Tom DeLay, who had read, I believe he read in the Washington Post, because there were a couple of articles at the time kicking around, where there was a white paper that was moving through EPA and NDC. And that white paper posited that EPA might have authority to regulate greenhouse gases. Sean Donahue, I think, and not, may have been the person who wrote that. But anyway, there were articles in the Washington Post about this. And Tom DeLay, I think, got wind of that. And Tom DeLay was the head of the Appropriations Committee in Congress. And the Appropriations Committee matters a lot because that's what controls who gets money. And so if you get crosswise with the Appropriations Committee, your agency might not be funded as well as you'd like, and that's bad. And so Tom DeLay is the head of the Appropriations Committee, and he's having the 1998 appropriations hearings to determine the 1999 budget. And he invited EPA, or the Appropriations Committee invited EPA to testify. And during that testimony, Tom DeLay asked what I think is a very important question of the then administrator of EPA, and that's Carol Browner. He asked Carol Browner, and I think, again, because of these articles in the Washington Post, does EPA have authority to regulate greenhouse gases? And as best I can tell, Carol Browner did not expect this question. This is not something that I believe EPA was planning to do at the time. But in response to the question, she thought about it and said, well, I think we do, but I'm not sure. And so Congressman DeLay asked Carol Browner, hey, can you look into that and give me a definitive answer as to whether or not EPA can regulate greenhouse gas emissions? And so she did that. She turned to John Cannon, who was then the general counsel of EPA, and she said, John, can you write up whether or not we have authority to regulate greenhouse gas emissions under the Clean Air Act? And Cannon did that. He wrote what's called the Cannon Memo. And I frame MASB EPA through the Cannon Memo because at that point you have an official statement by EPA that if they make a certain finding, then they can regulate, EPA, not only can, but are required to regulate greenhouse gas emissions. And so this leads to a petition for a rulemaking. There are provisions in the Clean Air Act that allow people to ask EPA to promulgate a regulation, to do a rulemaking. And so EPA got a petition for the rulemaking. They didn't act on it very quickly. There was a deadline suit. They were compelled to answer. When they answered, they denied this petition for this rulemaking. That denial of the petition for a rulemaking from a bunch of small NGOs is the essence of MASB EPA. That's the case that became MASB EPA. Now, these cases go in the first instance to the DC Circuit Court of Appeals. They skipped the district courts because of a provision in the Clean Air Act. And so this was litigated in the DC Circuit, who upheld EPA's denial of the petition that EPA regulate greenhouse gas emissions from cars under Title II of the Clean Air Act, under Section 202 of the Clean Air Act. Section 202 says that EPA shall regulate any air pollutant that endangers public health or welfare. I've got the key language up on the screen there. So if it is an air pollutant that's anticipated to cause an endangerment, EPA is required to regulate it under the Act. And so this petition said, well, we think that it's an endangerment, therefore you have to regulate. And that was the core of MASB EPA. And MASB EPA, and so following the Cannon Memo, there was another memo. It was written by there was a new administration. It was the George W. Bush administration. There was a new general counsel. His name was Bob Fabricant. Bob Fabricant wrote his own memo saying, we think that the Cannon Memo is wrong for a series of different reasons. It's public. You can read that memo. A lot of it came down to, we don't think that's what Congress intended to do with this law. We think that this is more of a political decision and it should be decided by policymakers, not in a regulatory sense. And so there was a basis for that denial. The Clean Air Act analysis looked directly at this language that we highlighted. It said, well, the question we think is fairly straightforward. We think that the question is, are greenhouse gases air pollutants? We think they are. We think that definition is broad. And therefore, if they are air pollutants, you need to determine whether there's an endangerment, EPA, and if you determine there is an endangerment, you shall regulate pursuant to the requirements of the statute. That's what MASB EPA stands for, is if there is an endangerment finding, EPA is required to regulate under Section 202A emissions from motor vehicles. There's a whole series of other regulations after this, but this was the start of it. And so that's the basics. That's the NACs, the SIPs, Title V, getting into MASB EPA, a little bit of mobile source regulation in MASB EPA. And now I'm going to turn it over to Sean, who's going to tell you what all this means.
Some of it, maybe. Yeah, thank you, Matt. All right. So, yeah, emerging directly from the story that Matt was telling about that really fascinating case of MASB versus EPA. And Richard Lazarus wrote a really great book about the whole story leading up to that decision, which I highly recommend to all of you. Definitely well worth reading. There's some really interesting twists and turns and characters in it. So the Supreme Court told EPA what it had to do after that decision. So EPA did go back and eventually, under the Obama administration in December 2009, issued a finding which was referred to in full as the endangerment and cause or contribute findings for greenhouse gases under Section 202A of the Clean Air Act. You know, that's a mouthful. So in short, we just refer to the whole thing as the endangerment finding. So recall that the provision in the Clean Air Act, oops, skip one there. that Matt already showed you before, the relevant provision is section 202. And incidentally, I'm going to pause here. Just like environmental law is confusing because of all of its acronyms, it's also confusing because pretty much any statutory provision you refer to has two different numbers attached to it. So you can see in the fine print, there's the US code citation, so 42 USC 7521. That's where it appears in the compilation of the US code. However, we also call it section 202 because that was the section number in the bill when the Clean Air Act was first amended, and environmental lawyers, for whatever reason, like to use the bill number. And I kind of feel like with the acronyms, it's sort of a way of making it an exclusive club that's harder for outsiders to penetrate. But I will generally be using the bill numbers referring to statutes, but I will also in my slides, I think, generally include the US code citation in case there's any lack of clarity there. So Matt highlighted the key language. The administrator shall regulate emissions of any air pollutant, and the Massachusetts EPA said greenhouse gases are air pollutants under this provision. Motor vehicle emissions, which in the administrator's judgment cause or contribute to air pollution, which may reasonably be anticipated to endanger public health or welfare. And notice, so there really are two findings that are embodied in this endangerment finding. It's really the first part is the endangerment, right? The finding that greenhouse gas emissions actually do endanger public health and welfare. And EPA, in issuing this finding, defined the relevant air pollutant as the mix of the six, key well-mixed greenhouse gases. So not just carbon dioxide, but also methane, nitrous oxide, hydrofluorocarbons, perfluorocarbons, and sulfur hexafluoride. Carbon dioxide is by volume by far the largest emitted of all of those, although the other ones have a higher greenhouse gas intensity. But it's the mix of them that the EPA made that initial finding to regulate. I'm highlighting that because that's becoming a very relevant issue right now, as we're looking at the future of the endangerment findings. So the first was that there's harm from these pollutants, wherever they come from. And then the second piece of it is this cause or contribute finding. And what EPA found then in 2009 is that the emissions of these greenhouse gases from motor vehicles contribute to the pollution that endangers public health and welfare. So all of that was wrapped up in the endangerment finding, was both harm from greenhouse gases and contribution from motor vehicles. So after making that finding, the result was that EPA then started regulating greenhouse gas emissions from motor vehicles. Initially doing that together with the National Highway Transportation Safety Administration, which issues fuel economy standards, and then more recently issuing separate rules. Alana's going to cover these in a lot more detail than I would have time for here, so I'm just flagging that this was really the first thing that EPA did, was start establishing, first thing EPA did to regulate greenhouse gases under the Clean Air Act was start establishing motor vehicle standards, and has continued to do so to this date. There's also, just flagging again for the next part of the talk, there is a provision allowing California to set its own standards in some circumstances, and that's also been something that EPA has allowed under the Clean Air Act, because the baseline, as Matt referred to, the baseline for mobile sources is federal standards, and there's only a very small carve out for state standards, unlike for stationary sources where the general structure of the NACs and the SIPs is that EPA sets the level of the pollution in the air, but states get to set the standards for individual sources. All right, I'm going to skip over mobile sources and move into what EPA then did regarding greenhouse gases being emitted from stationary sources. So Matt talked about new source review. So as a reminder, there's the prevention of significant deterioration from a PSD program that applies to attainment areas, so areas that are meeting air quality standards. And in particular, it's a permitting, it is a pre-construction permitting program for major sources. And major sources are defined in the Act as, for most kinds of sources, being ones that have the potential to emit 250 tons per year of a pollutant. For certain sources, the threshold is 100 tons per year. And then covered sources must use the best available control technology for each pollutant subject to regulation under the Act. pursuant to those permits. So the first thing you might think of is, if you're thinking about criteria pollutants like particulate matter or NOx or SOx, if you're talking about 100 ton per year or 250 ton per year threshold, generally speaking, the only sources that are going to need to get a PSD permit are large industrial sources. But if you're talking about emissions of carbon dioxide, which sources can emit in much greater volumes, you potentially end up with a situation where you have tens of thousands of sources that would need to get a PSD permit before construction. And if you think about the Title V operating permit program that Matt also talked about, you potentially have millions of sources that would need to get an operating permit based on these thresholds. So when EPA was looking at the application of PSD permitting, new source review permitting to greenhouse gases, the first thing they did was to develop something that they called the tailoring rule. And actually, one thing even before that, I alluded to the language, each pollutant subject to regulation, which is part of the trigger. EPA issued something called the triggering rule, in which they interpreted that provision to mean that as soon as greenhouse gases were the subject of mobile source regulations that went into effect, then at that moment when those mobile sources went into effect, then that was the trigger for greenhouse gases then being a pollutant subject to regulation of the Act. And then that then triggered the requirement of addressing them through the PSD permitting program. So having reached that conclusion and having looked at the pretty significant number of sources that would newly be added to that program, EPA developed something else called the tailoring rule. And this is also back, both those rules came out in 2010. And they decided, the framing of this rule was that they were going to phase in the permitting requirements because it would be burdensome to have to be immediately permitting all of these sources based on these original 100 or 250 ton per year thresholds. So the first phase addressed what they called anyway sources. So these are sources that already need to get a PSD permit based on their emissions of other air pollutants. And they said that anything that's an anyway source and that also emits 75,000 tons per year of CO2 equivalent. And so that's a way, CO2 equivalent is either CO2 emissions or it's emissions of those other 5 well-mixed greenhouse gases with a conversion factor based on the amount of warming they cause per unit of the pollutant. You can then even them out. So we say CO2e or CO2 equivalent. Generally, for a lot of these sources, it's mostly CO2 specifically. But so first phase was any sources that are already subject to permitting and emit that much CO2 equivalent need to address their CO2 emissions in their permits. Phase 2 would be other sources that didn't previously need to get PSD permit and that emitted 100,000 tons per year of CO2 equivalent.
Can I just highlight how unusual this is? You have statutory language and it says 250 tons per year. That's a small number. And then you have interpretive regulatory language saying, well, we're not going to do what you told us to do, Congress, at 250 tons per year. We're going to do this at 75,000 tons per year. So when you're looking at this as someone who defends these regulations, which is what I used to do, that's a problem. So that's all.
Yeah, which is why they tried to frame it as being, we are phasing it in.
Right.
They weren't saying we're never going to get to 100 or 250, but we're not doing that yet. Because, yeah, obviously there's a really big mismatch between 100 and 100,000. So not surprisingly, there was litigation over this. And this litigation eventually first went to the DC Circuit. As Matt said, their judicial review provision of the Act generally requires immediate review in the DC Circuit. First went to the DC Circuit and then went up to the Supreme Court. And in the DC Circuit, the EPA's actions were upheld, and including upholding the original endangerment finding. That was part of the case at the DC Circuit level, upheld as reasonable EPA's endangerment finding and the cause and contribute finding for mobile sources. When it went up to the Supreme Court, the Supreme Court doesn't take cases, they take questions, and they agreed to really just review the tailoring/triggering rule aspects of the decision. They didn't address the original endangerment finding at the Supreme Court level in this utility air regulatory group versus EPA case. And what the court did there is, so I mentioned there was a phase 1 and phase 2. Phase 1 is anyway sources, phase 2 is sources that go into PSD based purely on their greenhouse gas emissions. The court struck down the inclusion of those phase 2 sources in PSD permitting which was, in doing so, said that EPA could not trigger regulation based purely on greenhouse gas emissions. It held that EPA's interpretation of any air pollutant in that provision was unreasonable. This was also sort of an early manifestation of what has now come to be known as the major questions doctrine, a slightly different version of it than we will see in a later case that I'll refer to. However, it was, the decision was not a complete loss for EPA because the court did actually uphold the phase 1 permitting for any waste sources. Did this in part because the statutory language was a bit different. It was referred to each pollutant subject to regulation. It also didn't really bring on a huge new category of sources that would be regulated. These are sources that are already being regulated. They're just having to address additional pollutants in these permits that they already need to get. And there was also evidence for the court that the burden wasn't that great. The courts in this decision sort of left open the possibility that this started to become really burdensome. They might look at it again. But they were willing to uphold it based on that. So EPA, had a partial victory. They could continue in some circumstances to require greenhouse gas emissions to be addressed by sources through their PSD permits. EPA next looked at a different provision of the Act. This is Section 111. Section 111 of the Act, or 42 U.S.C. 7411, addresses what are called new source performance standards. So new source performance standards are sort of a supplement to the basic cooperative federalism architecture of the Act. These are standards that EPA can set for new sources that apply, they'll identify technology-based emission standards for a category of sources, and then those are federal standards that apply to all sources across the country that are in that category. You could look at it a couple ways. It provides a floor so that states have the flexibility of SIPs, but they can't, allow any particular news source to fall below that floor in terms of the amount of protection that is provided. It's also perhaps a way of looking at the concentration of harm, for communities living around sources. SIPs allow the emissions to kind of happen from anywhere in the state, but if there are new large sources being built that have to at least install a certain minimum level of pollution control, you're protecting communities near those sources as well. So, what's covered by Section 111 new source performance standards? Well, on the right side of the slide, the language tells the language from the statute telling EPA to identify, to list categories of stationary sources. And the category of EPA in doing so has to determine that the category of sources causes or contributes significantly to air pollution that may be anticipated to endanger public health or welfare. This is very similar to that Section 202 language, but not quite the same in a couple of ways. One, it doesn't say cause or contribute, it says cause or contribute significantly to. So that significantly language probably matters. And then it also says, you're listing a category of sources, that it's not that, it looks like you're not supposed to be making the decision based on the pollutant, but based on the harm caused by the pollutant, but based on the harm caused by the category of sources. These are live questions these days now. So that's what's regulated. EPA identifies the category of sources based on their harm, determines they have to be regulated under Section 11. And then what EPA has to do for air pollutants, for new emissions from new sources, it has to determine something called the best system of emission reduction that is adequately demonstrated. This is another acronym, BSER or BESER, that people will refer to. So EPA has to identify the sources, then set the standards, and these are federally applicable sources for standards for new sources. But to make things a little more confusing, Section 111 also, this is Section 111D, that was Section 111B, so standards for new sources. There's also a provision that applies to existing sources, even though this is called the new source performance standards section. What this does is it says that if you have a pollutant that is covered by a Section 111B new source performance standard for a particular category of sources, and if that pollutant is not a criteria pollutant, and it's also not a hazardous air pollutant, which is the next topic I'm going to get to after climate change. If it's neither of those things, then EPA is supposed to develop a plan sort of analogous to the NACS and SIP process for criteria pollutants. EPA is supposed to establish emissions guidelines and then have a process for states to implement those emissions guidelines for existing sources that are covered by this provision. So EPA then, for greenhouse gases, acted pursuant to its provision. So in 2015, under President Obama, EPA did a couple of things. First, EPA under Section 111B adopted new source performance standards for fossil fuel fired power plants. So these are newly constructed fossil fuel fired power plants. For coal plants in particular, this 2015 standard required them to capture part of their carbon dioxide emissions through a technology called carbon capture and sequestration. So that's where you capture the emissions of the smokestack, you send them through a pipeline, and you sequester them deep underground so that they won't come back up to the surface. So that has been the standard for new coal plants for the last 10 years. Of course, there have been no new coal plants built in that time, and at the time the rule was passed, it was not anticipated that there would be any new coal plants built. But that has been the standard. And the fact that EPA had a new source performance standard for greenhouse gases, which are neither criteria pollutants nor hazardous air pollutants, meant that the next thing EPA had to do was develop emissions guidelines under Section 111D. And then it also did that in 2015 through something that people came to refer to as the Clean Power Plan. And I mentioned that the standard applicable under 111D is referred to as BESR, the Best System Emission Reduction. EPA, in developing the Clean Power Plan, to identify what BESR was, looked at what they called 3 building blocks to identify for the power system what was the best system of emission reduction. And so the 3 kinds of things they looked at before arriving at the quantitative CO2 emissions numbers that were the guidelines for states, where they looked at what are things that power plants can do to reduce the carbon intensity of their electricity generation by increasing operational efficiency of coal-fired power plants. That's building block 1, increased efficiency of coal-fired plants. Building block 2 was shifting generation from higher emitting plants to lower emitting plants, so generally from coal plants to natural gas plants. And then building block 3 was increasing electricity generation from zero emitting renewable sources like wind and solar. So by combining, if a utility combined those 3 actions, EPA determined that cost effectively they could reduce greenhouse gas emissions by a certain amount. And through this, the EPA came up with the target, which was that through implementation of the Clean Power Plan, power sector greenhouse gas emissions would go down 32% from 2005 levels by 2030, 32% decline. However, the Clean Power Plan was stayed. It was halted before final court decision by the Supreme Court very early on, so it never actually went into effect. And then when the first Trump administration succeeded the Obama administration, they repealed the Clean Power Plan and replaced it with something called the Affordable Clean Energy Rule, or the ACE Rule. For ACE Rule, the BESR was basically that first building block I mentioned. Heat rate improvements, increased efficiency of coal-fired power plants. They concluded that EPA did not have the authority to take into account the second and third building blocks in deciding what the best system of emission reduction was. And then eventually that went up to the Supreme Court in a case called West Virginia versus EPA. The first thing is, before I even talk about the content of this decision, I will just mention that by 2020, so before this decision was before the court decided this case, and while the ACE rule was the governing rule, power sector emissions in the U.S. had actually already gone down 38% from 2005 by 2020. So in fact, by 2020, the Clean Power Plan goals had already been surpassed, which was partly due to increased renewable generation, but it was really partly because, in large part because natural gas prices had gotten very low, thanks to the increase in natural gas production through hydraulic fracturing. And so natural gas prices were low and gas was replacing a lot of coal, and that was driving down emissions as well as increased renewable generation. So eventually the Supreme Court took up a case that allowed them to address the interpretation underlying the Clean Power Plan. So I won't get into all the twists and turns about how it is that in 2022, they were addressing the, an interpretation underlying a 2015 rule that had been replaced in 2019, but suffice it to say that they managed to do it. And this is the case. So a couple of things about the West Virginia versus EPA case. One is that, and certainly for non-environmental lawyers, people who work in other areas of administrative law, this case is probably best known as being the one that for the first time really clearly and using the name adopted what we call the major questions doctrine now. And this is the concept that in certain what the court calls extraordinary cases, so not your run-of-the-mill case, but an extraordinary case that involve the agency exercising authority, where both the history behind it and the breadth of the authority the agency is asserting, as well as both the economic and the political significance of that assertion, as the court put it, provide a reason to hesitate before concluding Congress intended to confer that authority. So they'll, based on that, they would not, if you look at statutory language that perhaps in isolation could be read to grant the agency authority to do something, but based on all these other factors, the court would say, let's look a little more closely that, we should really hesitate before assuming this language means that, given all of the implications and the history and how broad this authority is, they're going to require more closely. And then, this is obviously, this decision is just 3 years ago. It's still the exact parameters that are still being worked out in the lower courts and in the Supreme Court itself, but it's obviously a really important statutory interpretation decision, and that's one of the things that came out of this case. And in applying that test, what the court concluded here was that Besser, interpretation that EPA adopted, those 3 building blocks in the Clean Power Plan, went beyond EPA's authority. And they didn't really specify more than that exactly, where the line was, exactly what part of what EPA did in the Clean Power Plan went beyond its authority. And in fact, I put a quote here on the slide. The court did make a point to specifically, point out the limits of the decision. So they did say, we have no occasion to decide whether Besser refers exclusively to measures that improve the pollution performance of individual sources, such that all of their actions are ineligible to qualify as Besser. So, the discussion around West Virginia versus EPA, sort of colloquially, a lot of the discussion people refer to it as sort of inside the fence line or outside the fence line, right? So are there things you can do, inside the fence around the power plant to reduce emissions versus things you might do elsewhere that reduce emissions, so that, those building blocks 2 and 3, building more solar and wind, shifting generation from coal to natural gas, those were conceived as being things that were outside of the fence line. And the argument was that EPA couldn't require those things. They could only require things inside the fence line. The court was careful to say, well, we're not saying they didn't absolutely rule out things beyond the fence line, but that was, certainly there was, suggestions that EPA had gone certainly too far beyond the fence line in the Clean Power Plan. Okay, so what has happened since then? I'm going to go over this quickly, and maybe we can get into it more in the Q&A. So after West Virginia versus EPA, the Biden administration went back and developed a new Section 111 rule, which it issued last year. There are multiple components to this rule. I will highlight just a couple of them, which was that for existing coal-fired power plants that were going to stay open beyond 2039, the Besser that EPA identified was 90% capture of CO2, capture and sequestration, so CCS of CO2. This is capture that's occurring inside the fence line of the plant, right? They're going to be capturing the CO2, sending the pipeline and burying it somewhere else. And then there were different standards for coal plants that were not in existence for as long. They also adopted new source performance standards for new natural gas plants. So remember, I mentioned in 2015, they adopted standards for new plants. They did not change the standards for new coal, but for new gas, they did say, if you're a base load plant, so a plant that's operating 40% or more of the time, I believe was the threshold, you need to also adopt 90% CCS if you're a new baseload gas plant. Different standards for gas plants that didn't operate as often, different standards for existing coal plants that will be retiring sooner. So those are the rules that were implemented last year. They've been challenged in court. That litigation has not been resulted in a court decision, although the case was argued before the DC Circuit last December. And EPA signaled a couple of months ago that its intent to reconsider or repeal multiple Clean Air Act rules, including this rule. And in fact, we have a proposal out that's in today's Federal Register, coincidentally. Comment period closes on August 7th for anyone who wants to weigh in. And in that proposal, they're proposing to repeal all of these standards, going back to the 2015 standards, based on the conclusion that fossil fuel-fired power plants do not contribute significantly to dangerous air pollution. So remember the language that I talked about in section 111 about cause or contribute significantly. So they're saying that the power sector does not contribute significantly, and that's based partly on a new interpretation of what it means. Previously, EPA had interpreted contribute significantly to be really about the volume of greenhouse gas emissions specifically. Here, they're taking other factors into account beyond just the amount of emissions, including they're saying what can be, the ability to reduce those emissions through what they consider to be legally permissible and technologically feasible measures. If you can't actually reduce them sufficiently, then they're not significant contributions in the first place, is part of the new interpretation. And then in the alternative, they go through each of the different standards. So I'm just going to focus on the 90% CCS for long-term coal. They conclude that that's not adequately demonstrated or cost reasonable. So they can't qualify as BESR because those are requirements for what it means to be the best system of emission reduction. And they go through and do that for each of the other standards as well. So they're proposing on two alternative bases. One based really on the legal interpretation that they shouldn't be regulated at all in the first place, and then the second based on what they consider to be adequately demonstrated. Although, because of their new interpretation to contribute significantly, that second piece kind of feeds into the first. So that's where we are right now, and maybe we'll get into that more in the Q&A. I'm going to go now pretty quickly through air toxics because I want to make sure I don't go on for too long, but I'm going to address this topic as well. So this is the topic of section 112 of the Clean Air Act, or 42 USC 7412. And so we refer to these a few times. Air toxics, also known as hazardous air pollutants, also known as HAPs as the acronym, also known as toxic air pollutants. What is it that distinguishes them from other categories of air pollutants regulated under the Act? Well, this is from EPA's website. They are those pollutants that are known or suspected to cause cancer or other serious health effects, such as reproductive effects or birth defects or adverse environmental effects. Some examples of air toxics are things like mercury, arsenic, perchloroethylene, benzene, asbestos. Generally, the one way of thinking about the difference between these and criteria air pollutants is, they're generally more harmful than the criteria air pollutants at low exposure levels. So they're, and often cancer causing, although not exclusively. Also, people's exposures to them in general are more limited or more localized. The part of the idea behind the criteria pollutants is that they are kind of, a lot of people all across the country are exposed to them in ambient air. And so the primary way of addressing exposure to criteria air pollutants is setting standards that's supposed to just reduce the level of exposure, the level of those in the ambient air for everyone. Hazardous air pollutants impacts are generally more localized, and so the approach has generally been to look more at the sources rather than set standard nationwide exposure levels to them. So Congress first attempted to deal with hazardous air pollutants back in the 1970 Clean Air Act amendments. And what they did there is they set health-based standards. So the requirement was that EPA set standards such that they provide an ample margin of safety to protect the public health. And really the result of this for the next 20 years was more or less regulatory. I think the phrase used in a Senate report from 1989 was regulatory paralysis. And there were a couple of reasons for that. I think EPA ended up, listing only 7 hazardous air pollutants by 1989. One reason is that, well, if you're talking about a so the statutory language is, set the level at an ample margin of safety to protect public health. Well, if something's a carcinogen, that can mean it's like, a non-threshold pollutant. Like there is in fact no safe level other than 0. And so if EPA is required to set emissions limits for these pollutants at 0, then you're potentially shutting down, huge segments of industry. If there's no way to get your emissions down to 0, the only way to get to 0 is to shut down. And that obviously would have, cascading consequences across all of society. One thing EPA did try to do to work around this a bit is it interpreted its authority to allow it to take into account cost and technological feasibility when setting these standards, but they were struck down by the DC Circuit on that in the vinyl chloride case. In the 1980s, the court said the language was clear, that the language said, this is what you have to do, set them at a level that provides an ample margin of safety to protect public health. There's nothing in there about cost or technological feasibility, right? And so the result really was that EPA was stuck. And so Congress in the 1990 Clean Air Act amendments really completely overhauled the approach to regulating hazardous air pollutants. First of all, the first question is sort of what are the hazardous air pollutants, right? EPA had hardly made any progress in even figuring out what pollutants should be regulated in this provision. Congress just took that upon itself and directly said, these following 189 chemicals are hazardous air pollutants, and still provided EPA with the authority to list more. And so they just cut that step out of the process altogether. They said, these are the pollutants you need to regulate. And then they set very strict time limits for EPA to identify categories of sources and set standards for them. And then also in setting those standards, they said that EPA, these are not health-based standards we're going to set. These are technology-based standards. So you don't have to figure out what's safe. You have to figure out what's achievable, but achievable in a very aggressive way. So for major sources, the EPA had, and these are based on, there's a quantitative threshold for what counts as a major source that's much lower, perhaps, than it is for the PSD program that I referred to earlier. They have to set maximum achievable control technology standards, or MACT standards. For new sources, that means that any new source has to be as clean as the best performing existing source. And for existing sources, so existing sources are also covered, not just new sources, and they have to be at least as clean as the top 12% of existing sources. So quite stringent requirements that can be determined objectively. So the idea was to really push EPA to act fast to address the harms from these pollutants, because Congress understood them to be particularly dangerous. There's also a provision for bringing in health later and for doing periodic technology reviews. There was, however, one exception to this, one carve out in the Act, was for coal-fired power plants, which you might not immediately think, why accept coal-fired power plants? I mean, you could say it's because of politics, and I'm sure that was part of it, but there was actually a logic to it, which was that at the same time in 1990, Congress was also adopting the acid rain program, cap and trade program for SO2 emissions that was just directed at coal-fired power plants. They were the only sector addressed by that. And there was a sense that the controls that you would need to install to comply with that standard might have the side benefit of reducing HAP emissions. So there's a sense, maybe we don't need to regulate them under Section 112 because cap and trade will take care of it. And there was also, mercury was the HAP of most concern from coal-fired power plants. And there was also a sense at the time, or some uncertainty about what happens to mercury once it's emitted. Is it more like a greenhouse gas that's kind of well mixed throughout the atmosphere all around the world, and such that regulating emissions in one spot's not really going to have local benefits, or does more of it depose locally? So the result was that Congress adopted sort of a delay and study approach for coal-fired power plants, told EPA to do some studies and to come back and determine whether it was appropriate and necessary to regulate these emissions. So that was the appropriate and necessary being the key term there. After a lot of back and forth, EPA eventually did conclude that it was appropriate and necessary to regulate these emissions. Appropriate because it found that actually a lot of the mercury emission emitted by coal-fired plants does depose locally or regionally, and so you can get a benefit from regulating them. And then also necessary because it turned out in the end the acid rain program didn't have much of an effect on mercury emissions from coal-fired power plants. And then based on that, EPA adopted a rule called the Mercury and Air Toxic Standards, which for the first time limited HAP emissions from coal-fired power plants. This also went up to the Supreme Court. I'm not really going to get into this in any detail because I know I'm going over time. I'm just going to say that the court concluded that the word appropriate meant EPA had to consider costs in deciding whether to set these standards. But this went back down to EPA. EPA ended up reaffirming the appropriate and necessary finding. Those original 2012 standards have been fully implemented. The most recent confirmation of that finding was not challenged in court after it came out in 2023. But then what also happened was that EPA did strengthen those MAT standards last year in 2024. Those were challenged in litigation. That litigation was not resolved. Then there are several things that have started to happen under the new administration. One is that pursuant to a, I think, never previously used provision of the Act, Section 112I4, President Trump granted 2-year compliance extensions to those new updated MAT standards, where I think it was 68 coal-fired power plants. And then also, coincidentally, in today's Federal Register, proposed to repeal last year's MATS update rule. Those comments are due August 11th, not August 7th, like the other ones. And then there have been also other actions or signals of actions to weaken or undo other hazardous air pollutant standards for other sources. So I'm going to stop there and hand it off to Ilana for the next topics.
Well, you guys might need a little brain break. That's a lot to take in. I've been practicing for 20 years in the Clean Air Act, and that you guys did such a wonderful job. And Karen, thank you for setting it all up. I think you did a really good job setting it up. And I think what you heard about Title I made it very accessible. At least I hope it did. The very complex area. Title I gets a lot of attention. I'm going to talk about Title II, which gets a little less attention. But first, I just want to thank ELI in the back for continuing this wonderful tradition of environmental education for the next generation of environmental lawyers. It's fantastic. And I think all of us on the panel welcome you guys reaching out even after today. You have any questions or even about, careers, right? Like I actually started at an NGO before I went to law school. And then all I wanted to do was work at EPA, which I did for 10 years. And now I'm in private practice. And I know all of us up here have our own special, career path. So I think anyone who's interested in environmental law these days, and we're all happy to talk about how we got to where we are today. It's almost a little bit exciting to have a captive audience to talk about Title II. But I think you're going to leave here at 2 o'clock no matter what. So bear with me. It just doesn't get as much attention. I think Karen touched on it a little bit because Title II sources are not regulated the same way Title I is, because it's all pretty much centralized at EPA, except for California, which all of us have now said that, and I will get to it. But Title II is in the news a lot recently, and you experience Title II every day, whether you're in your car, riding a bus, and all other types of engines and vehicles. So that's what we're going to talk about today. And my hope is to give you an orientation into Title II. So it's not as complicated as Title I. I am going to try to hit all of the major components. So when you walk out of here today, at least you have some bearing if you ever had to, at some point in your life, practice in Title II. Like, I remember that day at ELI when that lady was up there talking about Title II. All right, so let's get to it. We are going to start with mostly Title II. It's a little bit on enforcement, which I will cover at the end. Hopefully we have time. Within the Title II area, we're going to start with regulation of vehicle and engine emissions. So that's that top little circle up there. And within that top little circle, we're going to talk about federal EPA authority to regulate. And then we're going to talk about state preemption. Actually, the Clean Air Act preempts states from having their own laws, except for one state, which is California. So we'll talk a little bit about that. And then the Clean Air Act also has this fun provision called Section 177, which allows any other state to adopt California's laws. So we'll talk a little bit about that too. Then you see regulation of fuels. It's behind me. I'm pointing over there, but it's behind me also. And EPA has authority to regulate conventional fuels, but I'm not really going to talk about that. What I am going to briefly talk about is the renewable fuel standard, which is also tucked into that provision. And then, time permitting, we will cover Clean Air Act enforcement, civil. So there's administrative, there's civil judicial, there's criminal, and then we talked a little bit earlier about citizen supervision. So I'm going to try to very briefly touch upon all of those. Okay, so this is up. Okay, there we go. Title II is composed of 3 parts. You'll see part A is not grayed out because that's the part that we're going to focus on today, but you should know aircraft emissions under part B, and then clean fuel vehicles under part C. So what we have, and you've been hearing a lot about these pollutants so far today. It's very much the same types of pollutants that are regulated under Title II. These are criteria pollutants that will contribute to human health and environmental issues. And in particular, think about smog. And you have also particulate matter pollution. So EPA has the authority under the Clean Air Act to regulate these pollutants coming out of these mobile sources of emissions. And there are 2 types of emission sources that come from mobile sources. There's the engine's exhaust. So think of, we were talking about power plants earlier. Those are like very massive combustion sources, but your vehicle also has its own little engine, its own little combustion source, and then it goes through an exhaust system, much like the stack of a huge power plant, and out your tailpipe comes the exhaust emissions, and that's what's going to be regulated by EPA. But also EPA regulates evaporative emissions, and so that's from your fuel line. You can also have pollution coming out, you just evaporating, and so EPA also has regulations that address that. Just focusing on well, I'm not going to spend too much time focusing on the regulation of the air pollutants. Just know that that's generally what EPA is trying to regulate for the category of mobile sources. And then we will cover CO2 and greenhouse gases, and there's a lot that's happening even as recently as last week, and it's a very active area, as Sean was also mentioning in his discussion. So here's where we get to have fun Clean Air Act vernacular. So you've got these 2 categories of regulated mobile sources. You have what's referred to as on-road, and there you see light duty vehicles. So that's your passenger vehicle. So your car, that can also include pickup trucks. Then you have heavy duty vehicles. So think, the big 18-wheelers, really big trucks, as well as buses. And then you have motorcycles. And that's all under the category of on-road sources. And then you have this other second category of non-road sources. And you can see there's a lot of other circles there for the non-roads. And that is a really diverse set of engines that are powering either equipment, which regulate as equipment under the regulation, or just engines that are regulated on their own. And so you see we have something as small as, a lawnmower, and something as big as the engine that powers a cruise ship. All of these sources are regulated by EPA. So this slide and the last one were sourced from EPA's website. And I really like this image. I think it does a really good job of explaining how EPA and industry goes about reducing emissions, focusing mostly on tailpipe emissions here. And if you look on the left, you see the catalytic converters, and you'll see diesel filters also somewhere to the right a little bit. That's considered after treatment. So someone mentioned scrubbers earlier. It's all the same type of conceptual technology, right? You need some sort of a pollution device that is going to control emissions from this combustion source. And so the catalytic converter is one way to do it. These diesel particulate filters is another way to do it. But EPA also achieves this, and industry also achieves this through other ways as well. So we have these fuel standards, and if you think about unleaded gasoline, that's one way EPA is addressing regulation of fuel. You also have engine technology, so that's that third one over. And that's where manufacturers can really improve the efficiency of the design and operation of their vehicles, and that helps achieve greenhouse gas reductions, or on the the NHTSA, which is not, EPA doesn't regulate fuel economy, but I think you're all familiar with your fuel economy labels, right? And that's another way that manufacturers are able to achieve better fuel economy, is by improving the design of the products that they're selling. And then the one that's the penultimate, the alternative vehicle technologies. So that's your, plug-in electric vehicles, that's hybrid. It's another way that manufacturers can reduce emissions from these categories of regulated mobile sources. All right, so like Sean, I'm using the Clean Air Act site here. So when you go to the 42 USC, you won't see these, but these are the Clean Air Act provisions. And we picked there's a couple to highlight that I will very briefly walk through. So section 202, 206, 207, you see on-road vehicles and engines. So it's kind of like the heart of EPA's mobile source authority for on-road vehicles. 202 allows EPA to establish emission standards. We've already been talking about 202 a little bit today. Section 206 is EPA's authority to issue what's referred to as a certificate of conformity. I'll explain what that means. That also has an acronym. It's a COC. But that's really kind of like the license, the ability for anyone to sell an engine in our country. You have to have a COC. Under 206, you also have authority for EPA to conduct its own testing. And EPA also has the authority to revoke those COCs that I mentioned earlier, which is a very powerful tool that EPA has. Section 207 covers your emissions warranty. So if any of you have purchased your own vehicle and you like going through the paperwork, you always have to sign, like there's this form related to your warranty, and it comes from the Clean Air Act. Your emissions warranty is baked into the Clean Air Act. You have a performance warranty and you have a defect warranty. That all comes from Title II of the Clean Air Act. Moving on to non-road engines, EPA's basic authority to establish emission standards is in 213. Fuels and the RFS program, the Renewable Fuel Standard, we're going to cover that briefly today. That's under 211, and RFS is 211.0. And then on the right side, we have the investigative authority and prohibited acts. And this is also a really important piece of the Clean Air Act from EPA's perspective. So section 208 gives EPA the ability to investigate potential non-compliance by manufacturers. And it's basically an administrative subpoena. And in EPA compel the production of documents and testimony. And then section 203 lists out several prohibited acts. And there have been a handful that have been used more recently and getting kind of a lot of focus starting probably in the 2015 time period. So one is, selling a vehicle that's not covered by a certificate of conformity. And EPA has taken the position that if what you're selling, what you're putting in the market is different from what you put in your application to EPA when you're trying to get your certificate, then you are selling an uncertified product, and that's unlawful. There's also the in the application process, you have to identify all of these, what's referred to as auxiliary emission control devices. They're AECDs for short. I mean, we really do love our acronyms, guys. And there's also a prohibited device called a defeat device. And so there's been a series of cases starting in the 2015 time period around undisclosed AECDs and defeat devices. And then also rounding out this list, look, this is not a complete list, but EPA can, EPA treats a prohibited act is failing to provide information to EPA when you receive a section 208 request, as well as tampering with your emission control system. And EPA, it no longer has a national enforcement initiative in this area, but for many years, EPA was focusing on going after these aftermarket tampering cases where people were purposefully defeating their control technology in their vehicles to improve their vehicle performance. All right, so we're now going to talk about the certification process, and what we have here is really kind of like a three-step process. We start first with pre-certification, and this is on the manufacturer to come forward with all of the information that's required. And there's a long list in the CFR, and there's various CFRs that I've not listed here that cover all of the different engine categories that we had on that earlier slide. So manufacturers have to put together their application. They have to cover all of the information that EPA specifies, and this includes how their engine is designed. They have to have various types of emissions data. They have to very thoroughly explain their emission control system, including those auxiliary emission control devices, or ACDs that I mentioned earlier, because EPA needs to make sure that companies don't have any defeat devices, which I mentioned earlier. And, a defeat device is an auxiliary emission control device that is not justified under EPA's regulations. So EPA is very vigilant about making sure there aren't any undisclosed ACDs or defeat devices. EPA, as part of the certification process, will ask companies a lot of questions about their applications. And there's a really kind of a back and forth with EPA about what's included in the application, and make sure EPA has transparency in that process and what they're going to be certifying. So on this slide, we're describing this as an annual process, and that might come as a surprise to a lot of people, but every vehicle, you have to get it a certificate to sell that in a year. And after the end of that year, that certificate expires, and then you have a new model year, right? I'm sure you guys are all familiar with model years, vehicles. So each new model year, you have to get another certificate of conformity. So EPA is quite busy working on issuing all of these certificate of conformities to all of the manufacturers, not just of on-road products, but also of non-road products. But once you get your certificate of authority, then you're allowed to sell that vehicle or that engine in the United States. After you have your certificate of conformity as a manufacturer, your obligations do not end there. There are various post-certification requirements that EPA is also particularly vigilant about. So we've got several categories here, starting with the testing category. So we have what's referred to as production line testing. That's like literally a manufacturer taking a product off the production line and testing it. They have to do it randomly. There's a lot of requirements around that process. But that's one way that EPA has some assurance that what they've certified will meet the emission standards that manufacturers said that they could meet. There's also in-use testing. And I don't know if any of you have ever experienced this, but literally these manufacturers have to go out into the market and procure products, vehicles, or engines to test. And you usually get some compensation to allow them to come take your car away from you for a certain amount of time. And this is a really important part of EPA's program as well, to ensure that these products that are in the field operating under real world conditions are actually continuing to meet the emission standards to which they've been certified. We also have defect monitoring on the screen. That's a process where manufacturers monitor various pieces of information that they collect to determine if they have an emissions related defect in any of the components that are relevant to controlling emissions for that engine or vehicle. I mentioned warranty coverage earlier, so I won't talk about it again. Then we have recall authority. Recalls can be voluntary or ordered. If it's an ordered recall, it means that EPA has determined that there are a substantial number of that product, whether it's a vehicle or engine, that do not conform to EPA's regulations. And so EPA can require that manufacturer to go and fix them. It's quite unusual to buy back. Typically what a manufacturer is doing is going in and implementing a repair. But this is a very coordinated effort. And because you think about if it's your car, there's a lot of cars that are sold. So it takes a lot of time and resources to go out into the market and recall those vehicles. And then the last category here is one of, I think, EPA's a powerful tool it has in its toolbox is to void that certificate. So I said that that's this license that you're given to sell your product, and the statute allows EPA under certain circumstances to void that certificate so that as a manufacturer, you can't continue to sell that product during that model year. Okay, I'm going to talk about greenhouse gas. I'm going to be brief, but very active area right now. So we talked earlier about the predicate endangerment finding, and that then gave EPA the ability to regulate tailpipe greenhouse gas emissions. And that first model year started with model year 2012 and then has continued on. And actually still does exist today. So the Biden administration, before leaving office in 2024, issued two different greenhouse gas regulations. This one on the slide here applies to passenger vehicles. So, that's the light duty vehicles I mentioned earlier. So cars and your pickup trucks. And then they also issued, EPA Biden administration issued the phase 3 greenhouse gas emission standards for heavy duty vehicles and engines. And these new requirements, so for passengers starting in 2027, as well as the heavy duty trucks and continuing through 2032. And so those were issued back in 2024 before the Biden administration left office. And then not too long ago, in March, we had EPA announce that it is reconsidering the endangerment finding from 2009, as well as evaluating various of the mobile source provisions that are predicated on that endangerment finding, including that light duty greenhouse gas provision that I mentioned just earlier, as well as the phase 3 heavy duty standards. And, I think you can look at that recent activity, and Sean, you mentioned it, right, for the rule that was released last week on the greenhouse gas regulations for coal-fired power, that's probably an indication of what's going to be happening in the mobile source space as well, that, there will be a dismantling of the greenhouse gas regulations in the transportation sector as well. I will say, so NHTSA, I mentioned NHTSA, National Highway Safety Traffic Administration, has independent authority to regulate. They're not regulating greenhouse gas emissions or CO2, they're regulating fuel economy, right? So having fuel economy provisions in place, and that's not touched by the endangerment finding itself. And I don't know if there's some interest in the current administration to revisit the fuel economy standard, but that really is not going to be affected by the endangerment finding. Although EPA and NHTSA do have what's referred to as one national program for regulating fuel economy and greenhouse gas emissions together. Okay, so we're going to talk about California and the Section 177 states. So Karen did a really nice job of laying out the history of the Clean Air Act. In the 77 amendments, Congress added both Section 209 and 177. So we're going to talk about that very briefly. So 209A is, as I said earlier, a general, it's an express preemption of any state regulation of mobile sources of emissions. And at the time that Congress enacted 209A, California already had its own mobile source program. And so what we see now in 209B actually is a waiver of that preemption provision in 209A. And only one state can qualify under 209B. I don't know if you can see it, but there's this reference to having a program prior to March 30th, 1966. So that's California. California is the only state that can avail itself of the waiver provision in 209B. And California has consistently over the years availed itself of the waiver provision, not just for greenhouse gas emissions, but for various criteria pollutants as well. California, has its own challenges. I'm sure our state representative up here can talk about the difficulties that California has in controlling air emissions in that state. And so mobile sources is an important tool for California's toolbox to regulate air emissions. So 209B allows California to do that. Then we have Section 177. So Section 177 of the Clean Air Act allows any state to then adopt California's regulations, but there has to be a waiver for that California provision in order for a Section 177 state to avail itself of that. And for the Section 177 states, the standards have to be adopted at least 2 years before the start of the model year for a Section 177 state. All right, I'm gonna try to quickly go through the some really late breaking activity here with California and its preemption waiver. So we have here three joint resolutions on the screen. These are all programs that the Biden administration had granted a waiver to California for before leaving office. And I, having practiced now in the environmental space for 25 years, I had heard about the Congressional Review Act. Every time especially when I was at EPA, every time the administration changes, you hear talk of the Congressional Review Act, but I really can't remember, and it's been used like 20 times before now. I really can't remember it like impacting me in a meaningful way. Like it just didn't resonate. But now we have 3 resolutions under the CRA that are nullifying the waiver that EPA granted to California. We'll very briefly talk about the CRA. I am not an expert in the CRA, but just to orient you guys a little bit. So it's a procedural statute that allows Congress to review and disapprove final agency rules, rules being a very operative term for these purposes. So what happens under the CRA is that agencies, when they promulgate a final rule, they have to report on that activity to Congress. And then Congress under the CRA has a special set of procedures under which it can consider that rule and has the opportunity to consider legislation to overrule that rule. So in May of 2025, so just a few months ago, Congress exercises authority under the CRA to revoke these the 3 waivers. So if you look into underneath the joint resolution, to the numbers at the top, you see the waivers that were granted, and each of those has now been revoked through that legislation. And the president signed that into law last week. It's noteworthy, the GAO, the Government Accountability Office, had very recently issued an opinion that the waivers are not rules under the CRA. And the Senate parliamentarian, who is an advisor to the Senate, also concluded similarly that these waivers are not rules. But we do have legislation, valid legislation that's been signed by the president related to these 3 waivers from California. I'll just note on this slide, there is well, I feel like I'm gonna do it really fast, guys. So in the CRA, it almost feels a little draconian. So in the CRA, you can't have another rule that's substantially the same as the nullified rule. So if you think about the consequences for California, meaning that they could never have another rule, for instance, that is regulating emissions that are covered by the 3 rules that got the waivers, and including their electric vehicles. This is a very big deal for California. And there's also a judicial review bar. It's very straightforward. It basically says there's no judicial review of Congress taking action on the CRA. And most courts have really declined to hear challenges to decisions made by Congress under the CRA. So it's possible that California really won't have its day in court given the judicial review bar. But California certainly is taking action. So California filed last Friday challenging the nullification of the rules. I haven't had a chance to read the complaint, but at a high level, understand that California is arguing that the CRA applies to federal rules, not state rules, so it's not an appropriate use of this authority to nullify the 3 waivers. And I'll add that 10 other states, these are 177 states, have joined California in that litigation. I am not going to cover the RFS because I think we are running out of time, but I will note EPA just last Friday released what's referred to as the Set 2 rule. And I think, so this is interesting. And in one of the executive orders that President Trump issued, the energy independence executive order, he did reference renewable fuel in that. And so this is, if you look at this through the lens of America First and energy independence, then you could see an EPA, a Zeldin Trump EPA really kind of leaning into this program, because it is also, not just getting greenhouse gas reductions, but it also is important to transitioning to domestic sources of fuel. And what's really interesting about this rulemaking, and it's just proposed, so it just went out for proposal on Friday. Obviously, there'll be a comment period before it goes final. But it's really kind of disincentivizing imports of foreign renewable fuel as well as foreign feedstock to make that renewable fuel. So we'll see what people say in the comments about that. I think we're out of time, really. Is that right, Karen?
Well, we do have some questions that have come in,
Yeah,
so
yeah.
maybe we should.
I will. I'm just gonna do a real quick wrap up. I, for 10 years, enforced the laws at EPA, so civil enforcement is kind of near and dear to my heart. Title I has various enforcement authorities, whether it's a SIP violation or a non-SIP violation, so 113A1, A3. There's civil judicial authority. There's also administrative authority, which means EPA takes the action before an administrative law judge. There are those at EPA. Title II, very similar to Title I, administrative civil judicial authority. There is criminal enforcement authority under Title I, and the United States has interpreted that to also apply in certain circumstances to Title II. And then, as we mentioned earlier, there's citizen suit authority, and this is under Title III. And it allows, private citizens, individuals to step in the shoes of EPA and enforce environmental laws. And we included here two different citizen suit cases, one under Title II, which we really hadn't seen a lot of citizen suit activity under Title II. But that was a 10th Circuit decision in 2021, finding that citizens could enforce that provision of Title II. And then there's an interesting Title I case. There's a pending petition for cert before the Supreme Court that would address standing under Title I. And there's you guys, maybe if you've gotten there yet, the 3-prong test to standing, injury, causation, and redressability. And so 2 of those issues will be before the Supreme Court and potentially revisiting longstanding Supreme Court precedent on standing and citizen enforcement actions. Thank you.
Thank you. Thank you to all our panelists. I'm joining in. All right, so we have some great questions that have come in over the chat. I'm gonna start with those questions before we talk to questions in the room, just because we might be able to stay a little late to address those in the room. How should West Virginia versus EPA be interpreted in light of Loper-Bright? And I can forget to Sean, I can just to set that up again. Loper-Bright is the decision that overturned the 40-year Chevron precedent. So courts are no longer supposed to defer to agencies' interpretations of ambiguous statutory authority. They're supposed to interpret statutes themselves. And West Virginia versus EPA is the 2022 decision that introduced that major questions doctrine, which says that when Congress is expected to speak to questions of tremendous economic and political significance. And why don't I turn it over to Sean to.
Okay, yeah, and I can speak
Yeah.
very briefly on this, and I'm interested with others panel,
Sure.
I think, too. I mean, I would say I don't want to speculate on how this is interpreted going forward, because that's partly subject of, existing or anticipated litigation that'll be involved. But what I will say that if you look backwards, I mentioned the utility air regulatory group versus EPA case involving the tailoring rule. And in that case, the version of the major questions doctrine that existed then was something that the court applied at step 2 of Chevron. So basically they said, statutory language isn't clear, and because this is a major question, we are not going to defer to EPA's interpretation at step 2 under Chevron. So it was sort of built into the Chevron framework. Then in West Virginia, there was a kind of a more muscular version of major questions the court adopted that wasn't part of that framework. So that if we were still back at the UARG version, then obviously getting rid of Chevron would matter a lot. But I think, the West Virginia kind of meant that it didn't even matter whether you would get into the Chevron framework at all. It was already sort of came before you would get to a step 2 question. So it's, but it remains to be seen. Obviously, part of what I think what was motivating the court in West Virginia was concern about sort of what they saw as overly aggressive agency interpretations of authority and a history perhaps of deferring to those under Chevron. So without Chevron, maybe there's not as much of a concern about that. But that would be, I don't know how that'll turn out in the future.
Yeah, I guess I would also weigh in and just point out that the arbitrary and capricious standard does still apply to challenges to statutes that are based on deficiencies in EPA decision-making, right? So Loper-Bright is about its interpretation of statutes, but a lot of times rules are challenged on the basis that, EPA had insufficient factual support for its rule or failed to consider certain comments and so forth. And that arbitrary and capricious standard is not only in the APA, it's also written into the Clean Air Act itself. So, we're still waiting to see how Loper-Bright plays out in the environmental Clean Air Act context. We had a speaker who asked if they think it's likely PFAS will be added to the current criteria pollutants list. And I'll start out by responding that PFAS is actually a hazardous air pollutant. So if it were to be regulated under the Clean Air Act, it would be under Section 112. And in fact, we actually had 3 states that have petitioned for EPA to add PFAS or for PFAS actually to the list of hazardous air pollutants, but that hasn't been responded to yet. I think what else okay, say about that. There was a related question. The compounds considered to be hazardous air pollutants were defined in the 1990 amendments by name, which is correct. There were 189 HAPs listed in the 1990 amendments. Since then, chemicals actually used and emitted have changed significantly. However, the list of hazardous air pollutants has not been significantly changed. What's the current legal interpretation about this? Can it be true that the list will never be updated and highly toxic compounds not on the list are ignored? And PFAS may be the best known example of this. So since that list of 189 HAPs was adopted, 2 of them have been removed from the list and 1 was recently added. EPA can add one on its own initiative, or folks can petition EPA to add a HAP. But yeah, obviously it doesn't happen very often.
Yeah, well, and that's part of the reason it was amended in 1990 is EPA had trouble going through the statutory process to list new HAP because it's a lengthy process, and part of regulating a HAP, you have to decide whether you're going to regulate under, under what principle. How much do you have to know about the potential harm to add it onto your list? And EPA was tied in knots over that for years, and regulated a very limited number of HAP between 1977 and 1990. And so, yeah, EPA, there are criteria in the statute that would allow EPA to add new hazardous air pollutants. I'd be really surprised if EPA had did that. And I should say, I should have said this before, I'm here in my personal capacity. I'm not speaking on behalf of the United States. But regulating HAP is tough. And that's the reason why there've been a couple taken off and 1 added to the list since 1990. It's possible, it's hard.
Yeah. Here's a good one. Is there anti-backsliding in the Clean Air Act? Can they simply eliminate the endangerment finding? There's
I mean, whether they will and whether they can rebuild the finding. Yeah, I can't really speculate on that. That's
specifically on that.
Yeah, something will be.
There are principles of anti-backsliding certainly in the Clean Air Act.
Yes.
Yes, this is going to be an interesting few years coming up. Here's a question about monitoring. Regarding using air quality stations to monitor for attainment or non-attainment for the NAAQS, is there a concern about the location of these stations? I believe Matt said the monitored locations are chosen by the states under the cooperative federalism model and approved by EPA. How stringent is the EPA in approving those locations? What is stopping states from choosing locations that help them achieve attainment? Yeah, to take the first stab at this. I mean, so EPA does have very stringent citing criteria for its monitors. It's in 40 CFR Part 50 Appendix A. And those criteria are designed to assure that the monitors are measuring air quality in a way that's representative of that pollutant for the areas in which or for the sources from which that pollutant comes from. So it'd be the stationary stores, roadside, and that they aren't obstructed by hillsides and such. And states do have to submit annual monitoring plans that get approved by EPA to show that they're meeting those citing criteria. And that is a stringent process.
Yeah, no,
Yeah.
that's exactly right, is states don't have the discretion to put their monitor inside a closet in a climate controlled room. It's like there are criteria, there's regulatory criteria that tell them where the monitoring stations have to be, and if it looks like they're fudging and they get caught, they're gonna get in trouble, they're gonna end up with a PIP, and they don't want that.
Monitoring equipment is expensive to run, and it requires personnel to operate. So, we don't have monitors just all over the place. There might be just one in a county or one in a series of several counties. So it is very important, these citing criteria.
And I just add on that, I think the big issue is the cost. And, obviously there are new low-cost air sensors that are being developed, but they're not currently able to provide data of the level that the emissions monitors that EPA requires would provide. And I'd say just, there was a Resources for the Future study from 6 or 7 years ago, I think, that used satellite data to suggest that for particulate matter, that there were maybe tens of millions of people who were actually, or if this satellite data was actually being exposed to particulate matter in excess of the NACs, but were living in areas designated attainment, and not because of any, malicious citing of monitors, but more just because you can only have so many of them. They're expensive, they take a lot of staff, and so you don't necessarily notice all the variations in exposure within a particular area that's covered by a single monitor. So there may be opportunities in the future for improvements in low cost air sensors or satellite data, or hybrid models incorporating multiple sources of data that might make it easier to identify exactly where people are exposed to high level of pollution.
One more question from the chat. Do the standards, and then I think this question means the National Ambient Air Quality Standards, adjust at all based on levels of another pollutant, i.e. if SO2 exceeds a certain level, that could set the standard for another pollutant at a different level because of some negative interaction. I mean, EPA evaluates each of the criteria pollutants, or I'm sorry, the NACs individually, and it does periodically review them. Doesn't it?
I mean, it's a health-based standard,
Yeah,
right?
they're
So
health-based
if there's an interaction that's liable to have a negative impact on human health, then the standard itself is driven by the criteria of pollutant. It's not driven by multiple criteria pollutants, but the health-based impact can be impacted by the interaction of chemicals. And there's also other programs that expressly consider the interaction of chemicals. And so the answer is kind of yes and no,
Yeah.
but I think the honest answer is yes, it's factored in, and there are periodic reconsideration and revision of the NAC standards based on current science.
Yeah, and when we talk about the NACs, states or areas have to attain the NACs. But some of the NACs, like for example, ozone is a criteria pollutant and it has a NACs, but the pollutants that lead to ground level ozone are NOx and VOCs. And so you have to regulate those precursor emissions in order to reach the ozone standard. It's interesting interplay. I think we've reached the end of our time. So in terms of the webinar, I would just like to again thank our wonderful instructors, and thanks to everyone who was able to join us online today. We really appreciated being here.
Yes, thank you all so much. Huge thank you to Karen, Matt, Sean, and Alana for joining us in person today. For the in-person audience, hopefully you can ask a few questions if a couple of our speakers can stick around. For our online audience, thank you so much. We'll be back next week for energy virtually, and then the following week in person for climate. So we hope to see you soon, and thank you all so much.
All right, thank you.
Yeah.
Thank you.